Okay,
There we go.
thanks a lot. Okay, so my name is Steve Rick, as Kathleen said. I am, my regulatory practice, at least as it relates to whistleblower type situations, is reactive in nature. I'm the guy you call when you get a notice of violation from the EPA or the DEC or a citation from OSHA. The focus of this presentation today is really about being proactive and about dealing with issues in-house. My colleague sitting next to me, Rick Pooler, has a significant in-house experience at a large corporation, and he's going to be discussing proactive measures before you get to the point where the agencies get involved. At least that's really the intent and the purpose of this presentation today. Normally our webinars are pretty heavy on regulations and statutes and cases and that sort of thing. Today it's going to be somewhat less of a technical legal discussion and more of a practical application discussion. So with that, I would just like to say that I'll turn it over to Rick Pooler.
Yeah. Let me just give a brief overview of what we're going to talk about today. As Steve said, we're going to focus on the practical things you can do, and a lot of the focus on the prevention part. Steve will give a little background. I'll talk about the 6 Ps, what I call the 6 Ps. It's proper planning prevents piss poor performance. And that's really the prevention part. You want to prepare and even prevent. If you're unfortunate and your prevention doesn't work, then we'll talk a little bit at the end of the presentation about how you actually work through an investigation, your initial response, the formal response, your closure, your corrective actions, and your monitoring, and how to do that. So, Steve, why don't you give us a little background?
So, we're using the term whistleblower synonymously, in the colloquial sense, the person who is bringing a perceived problem to the attention of management or a supervisor. Of course, we all know that there are whistleblower laws out there. These are the laws that are focused on punishing employers for retaliating against employees for doing this. There are whistleblower provisions in virtually every federal environmental and occupational health and safety statute. And when if you're unfortunate enough to both have an internal problem that's brought to your attention by an employee, which then triggers agency involvement such as EPA or DEC or OSHA with respect to compliance matters, you're in the absolute worst case scenario if you also have a whistleblower statute problem. That means that you are also being accused of punishing your employee or employees for starting the enforcement and inspection ball rolling. So as you can see on your screen, there are numerous statutes. What we're talking about today is managing in-house responses to employee complaints so you don't get anywhere near this. A little bit more background, however, on the whistleblower statutes generally. OSHA enforces whistleblower matters in which an employer is alleged to have engaged in retaliatory action towards an employee. The type of activity that's protected here can generally be described as complaining about something in-house or assisting in a complaint, providing corroborative information or documentation. Retaliation can take many forms. It's not always a clear-cut situation. It can be a demotion, reducing pay or time, denying overtime, denying promotions. It's kind of common sense. These are no-nos that you want to stay away from, absolutely. Whereas the underlying situation with the regulatory compliance matter might involve somewhat, containable regulatory civil penalties and corrective action schedules. The penalties for retaliating against an employee can be severe, and it can extend beyond reinstatement of back pay or benefits, and can include, the recovery of legal costs and fees. In extreme instances, there can be a judge has the discretion, if it gets to the solicitor's office and it goes to court, to levy treble damages, which is 3 times, whatever other damages have been suffered. So, kind of common sense, but obviously the last thing in the world you want to do when you have a situation of an in-house complaint is to in any way retaliate against the employee or employees in question.
Yeah, it can be the gift that keeps on giving. You solve the problem, and if you retaliate, it keeps the problem live in the organization, which is very distracting. All right, so there's several different ways that a triggering event could pop up. And when I say triggering event, and I think as Steve mentioned earlier, when we say whistleblower, it could be just somebody early on. I look at whistleblower across the spectrum. It's informal to formal. Someone coming forward, just raising an issue, raising a concern. They're a potential whistleblower if you don't resolve the problem correctly or to their satisfaction. So it's important to understand when that initial issue pops up, to look at how that is characterized or where the whistleblower is coming from. It could be that something is wrong and management is not responding. So the person is properly raising an issue. All right, that's one way. Other ways that other pathways for issues. Something might be okay, but appears to be wrong because the person doesn't understand it. Maybe they're not familiar with the operation. Could be a member of the public that sees something, a puff of smoke, something smells funny. Maybe it's just a system upset, but they're convinced something is wrong, even though it's really right. All right. And the third one, which is very sticky, that someone internally or externally, they try to muck things up for political reasons. So there's some apparent impropriety or real impropriety that's minor, and they pursue it for political reasons and try to make it larger and messier, more complicated than it is. And those are in some ways the most challenging.
And you're talking about in-house politics, office politics,
Yeah.
Pecking order issues.
Yeah, oh yeah. Well, it even could be outside. I mean, you could have an external political driver, see, with neighbors or something. You know, if the neighbors, maybe they lost at the zoning board, and they lost, so now they're going to want and try to bring pressure other ways. So it's more often internally, but it could also be externally. All right, so the planning. Let's talk about some planning part. One of the biggest things you can do, and you need to do this every day, is to protect your reputation. In real estate, they say it's location, location, location. EHS, it's reputation, reputation, reputation. Okay, you want to build honest, transparent, solid relationships with the agencies and with the public and with community groups before you need it. You want to have the trust of all those different external entities so that when you need it, you have it. You can't do it after the fact. They don't trust you. They're not going to suddenly start trusting you if you play nice after one of these issues start. We had a situation where we had a whistleblower. It was a very messy case. We did an audit self-disclosure with the state agency. We went above and beyond what the whistleblower claimed, and that bought us, in addition to our good reputation, we had built a very good reputation over the years with the agency, and then we came in and we went far beyond what the whistleblower was claiming, and the agency, they trusted us and believed us. It was a huge, huge benefit in resolving the issue. Now, the other thing that you need to be doing, again, on a regular basis, monitor your workplace. Issues will bubble up naturally, all right? If you're listening, if you're taking things seriously. And sometimes it's connecting the dot. It can be a little bit of a puzzle, a little bit, and you may get, comments or mentions of situations from, from employees, from contractors, from neighbors. So if you look at, if you can look at those, they can give you clues to where there might be an issue, and you can dig in a little more and maybe understand an issue or head an issue off at the pass before it causes a problem. Okay. Now, another part of the planning and preparation process is your internal management system. All right, and this will vary from a big company to a medium company to a small company. But I think you still, even if you're a small company, and you have people who are wearing many hats, you should have some of those hats should be some of these items we'll talk about here. Larger company, they'll have whole departments doing these, but that still doesn't mean that even as a smaller company, you can be aware of that. So a larger company, the large and more bureaucratic approach is what I have listed here. You could have a formal ombudsman, compliance officer, compliance department, okay? But you still need a complaint mechanism. Could be a complaint box, could be a phone, an email, but it has to be serious, all right? It can't be, yeah, we want to hear your complaints, but then, you know, we're going to penalize you, you're going to get harassment, and that can lead to some of the things Steve talked about earlier when, you know, if it looks like there is harassment or retaliation, you've got a whole nother problem down the road after you resolve the actual whistleblower. So your complaint mechanism has to be real, and the employees have to believe that if it's anonymous, it needs to be kept anonymous, so that there's some sort of a system there to collect complaints. It could be a direct discussion with management, right? So whether there's a formal complaint mechanism, it could be over the coffee pot. Somebody mentions, gee, something strange going on down in building number 2 or whatever on the, you know, some certain line. So you want to listen and take those types of things seriously. And then lastly, you should have a policy requiring employee cooperation in investigation. And this is very important because employees, once you get into any level of investigation, and especially as the investigation gets more formal, all right, employees are reluctant to look like they're undermining their coworkers, all right? So you have to have a policy up front, make sure people are aware of it, make sure that there won't be any retaliation, that people need to cooperate and tell the truth in an investigation.
Yeah, these are all good points. I think what I would add, you know, a lot of the clients that I represent tend to not be large corporations with different departments with a clear division of labor. So what I would say to a smaller shop listening in, you're probably going to have a situation where an individual is wearing multiple hats. Your foreman, your operations manager, possibly even the owner might have a HR, environmental health and safety, and operations responsibilities. In instances like that, the problem I see recurring time and time again is a diffusion of responsibility. If there aren't clear roles among your staff and management, this is when things fall through the cracks. Obviously, in some instances, you're going to have a process safety management plan that sets out these sorts of things. But you know, I guess it should go without saying that when you have such plans, you should be familiar with them. You should review them periodically and regularly. You should update them as necessary, particularly when there are personnel changes. There should be regular training so that everybody knows what their function is. Because when you get to the point of an internal employee complaint, it's quite useful to have a pretty clear path for voicing the complaint and resolving the complaint.
All right, another part of planning is you want to think ahead of time about who would be on the team. All right, so when you get some sort of a complaint or a concern comes, you know, bubbles up, all right, you want all of these people probably at some point on the team, and maybe by the end of the process, everyone is formally on the team. But typically, you would start generally with subject matter expert. Sometimes it might be HR. I'll give you 2 examples. I mean, subject matter expert, if, you know, and we're talking EHS here. So someone thinks there is a problem from an environmental perspective or health and safety perspective. So you would want the specialist, the subject matter expert, to be involved, so you can hopefully assess fairly quickly, is there some legitimacy to the claim, or do they not understand it? It'll be a very different approach. You know, if the whistleblower just doesn't understand it, then you've got to explain to them why it's okay. If there really is something wrong, you've got to fix it. And you want your subject matter expert, whether it's air, water, waste, fire, safety, whatever that may be, to be involved up front and understand what the complaint might be. You might also have human resources. Occasionally, I've been in situations where we would get a letter, and the letter is trying to reopen something where someone, you know, where the employee claims they were treated unfairly. So there was a prior investigation. In that case, human resources would typically be where I would start to say, gee, there was an investigation, there was a whole process. Was this handled properly? Was the employee handled properly? And sometimes you might go to human resource to kind of recap what had happened in the past. But all of these parties, you would want, again, I think typically more than not, you would start with a subject matter expert. You would have legal involved if there's a compliance concern. Security could be involved. They're very good. Many times your security professionals are ex-police officers, ex-agency investigators. They can be very helpful in interviewing people, in making a judgment of, sincerity. Is somebody lying? Are people being invasive? And folks that come out of that realm are really very good at helping you cut through the fog in those situations. Leadership, you may or may not involve leadership. I mean, when you do some sort of investigation, people will see that you're starting to nose around. So you will have to tell some, people what you're doing in general. Sometimes you may have to be a little bit evasive over what the real purpose is, depending on how sensitive the matter is. And of course, public affairs, you want them to be prepared in the event it gets external, if it doesn't start external, because any of these situations could go external, and you want your public affairs people prepared and ready with statements in case it does head in that direction.
So with respect to subject matter experts, so obviously again, there's going to be a range of resource capabilities depending on what company or facility we're talking about. Certainly in many instances, outside expertise is going to be required. Many companies, but not most companies, have relationships with law firms, consulting firms, and the like. And it's a good idea to keep those relationships intact. And we all know that people move around in the consultant field. People move from law firm to law firm. So you definitely want to sort of pay attention to who your experts are and just sort of make sure that when the time comes that you need them, you've got a pretty good idea of who can do what where. Sometimes easier said than done because of the degree of mobility in these professions.
All right, so those are some of the ideas and concepts around planning, but let's talk about when that contact is made. This is the awkward phone call, email, letter, conversation, whatever it may be, where the whistleblower or a potential whistleblower raises an issue. All right, now you need to understand the whistleblower may not fully understand the situation. They could be right for the wrong reason. And sometimes they're difficult and annoying and you don't like them. And that's okay. But most of the time, the whistleblower is raising, a potential whistleblower, they are raising genuine substantive issues. I can't think of the scores of situations that I've worked on over my career. I can hardly think of one that was totally off. The only ones where there was nothing were what I referred to earlier. Maybe some letter came back where someone was trying to revisit an issue that was closed. Sometimes there was nothing there. These were the people with the tinfoil hats or whatever, and they just can't, get over it. Those are really the only times that I can recall where there really wasn't something to open up again. But there generally is a substantive issue behind what they're in. This is not easy for someone to raise an issue casually, as I said, on the one end of the spectrum, that's one thing. But the more formal you get, it's not easy to do. People realize they're stirring up a hornet's nest, and especially nowadays, and you see what the headlines are, everybody realizes, whistleblowers will be on everybody's mind going forward as to how confusing and difficult these situations can be.
So a couple points first on the difficult employee. We all know that there are instances where ulterior motives exist. You've got an employee possibly that's got a bad track record in your shop. Maybe someone who doesn't follow the rules, somebody who maybe has an axe to grind because of an employer's lawful sort of management of bad conduct, frankly. As far as the HR member of the team, certainly it always makes sense to keep a good, well-documented personnel file on individuals like this, because with respect to credibility and dealing with regulatory agencies, although we don't want to blame the complainer and we certainly want to be productive and not engage in any retaliatory acts, if there's a situation where there's an employee with frankly, his own bad or her own bad reputation in your shop, if you got documentation of that, it's often useful if you are unfortunate enough to be dealing with a regulatory agency. Another thing about retaliation, and I don't want to spend too much time on this because it could be the subject of a whole nother discussion, but you know, I mentioned that OSHA is sort of the police person when it comes to retaliation. We know that there are injury and illness record keeping obligations that have evolved over the past couple of years. In the fall of 2018, OSHA issued guidance clarifying when certain types of legitimate employer programs could be, whereas you know, safety incentive programs and drug testing programs can be applied in a punitive retaliatory nature. There's guidance from OSHA that you should be aware of, October 18 guidance on how to make sure that if you do have a safety incentive program or a drug testing program, how to avoid no-nos. So, you know, on sort of a very general level, a safety incentive program that doesn't reward employees for bringing unsafe conditions to your attention is a red flag. You want to avoid a situation where the only motivation among your employees is to hide or eliminate any departures from safe practices. So there has to be a balance. Same kind of notion with drug testing programs. Somebody complains about an injury, you don't drug test only the complainer. You know, you want to have an even-handed situation where you're not discouraging employees from bringing complaints to the attention of the employer.
All right, so if you haven't been successful in preventing, then how do you respond? All right, well, we talked about the team. So if you're into a formal response, into some sort of response, get the team together. And depending on what the, you know, what we talked about earlier, what it would be, the team would be at least a few people off of that list I had earlier. It might be all of them, at least initially. And then you'd break up into a smaller team to proceed. So at least everybody is aware. But the team, you know, that first response, you got to figure out which way to go and how are we going to handle this. And that's why you generally will have that first call might be a few more people that are really going to be actively involved, but you want them to be aware of what's going on. And things could move very quickly, so you want, you know, you want them to be briefed on it. So if you have to pull any of those people in quickly in a week or two, they're not blindsided. So they're ready to roll and move quickly to support you, all right? So you put the team together. You want to keep it confidential, obviously, for obvious reasons. All right, you're going to notify management, but there might be parts of management you don't notify, depending on where the whistleblower or potential whistleblower, you know, where they're pointing a finger, who they're pointing a finger at. So there's different levels of notification within management. You've got to look at that. Contact the whistleblower. All right, and this could be again, you've already had some sort of contact, but this would be a more formal contact. You want to confirm your understanding of the issue. Again, this might be with the subject matter expert now, okay? Confirm the understanding, assure this person that it is going to be thoroughly investigated, taking it seriously, and set up a communication protocol, because you don't want the whistleblower jumping the gun, going to the newspaper, going to the TV station. You want to have a communication protocol so you can let them know how you're investigating, how the investigation is going. Generally, it goes slower than they would like. They think it's like the movies. You're going to go in, everything's going to happen quickly, and all good things will happen, and it just doesn't work out that way. It's generally much more complicated and convoluted. So you need to manage the whistleblower's expectation on time and speed of the investigation. And communicate with them. And there may at some point be an agency notification, and you want to be totally aware, again, with the whole team on when and how that's going to happen. And when that happens, again, that would be public. So you're really going to go, you're going to be reaching across a lot of boundaries internally if you push the button for some sort of a public exposure to what is happening.
So I guess what I would add is all this translates, if you proceed in a methodical way and you set up clear responsibilities and a clear path of communication for the employee, what you're doing is building trust. And trust is got a mutual benefit, and it's a good investment. If you do not follow up, if you do not get back to the employee, it enhances the likelihood that that employee is going to feel betrayed, and it's going to increase the likelihood of a third-party notification, whether to an agency or to a newspaper or whatever. What we don't want to do is make a molehill into a mountain. And we're not talking about, there's movies where whistleblowers are in the tobacco industry, and it's this, sort of, societal issues. There could be very mundane issues. We know what the typical OSHA violations are: fall protection, hazard communication, scaffolding, ladders, industrial trucks, machine guarding. Little stuff sometimes can really set in motion an internal complaint. In the event that you fail to address what might seem to you to be a mundane matter and you prompt a third-party notification, the molehill can become a mountain in the sense that it can and probably would lead to an inspection of your facility. So it's definitely a good investment to take every employee complaint very seriously.
Okay. As you move forward with the official response and the official investigation here, the team, and we've talked about this through some of the slides already, is it internal, is it external, is it combined? How do you balance that? And there's no set rules. I mean, you really have to look at how you would bring in experts. And you can already see from the list that I had earlier of the people that would be involved, now we've got internal and external people, and you really have to watch out for the herding cat syndrome at this point. Because every time you add a person, it's that much more difficult to manage, all right? But it is what it is. You need the right people. You still have to have, if certain people need to be involved, depending on the scenario, then they need to be involved. And you could have a fairly large team that can be unwieldy to manage, all right? You should be looking at self-disclosure options. On the environmental side in particular, there are specific self-disclosure protections under a lot of environmental statutes. OSHA does not have a formal self-disclosure process, but you would get credit for disclosing in any kind of enforcement action. You have to look for individual conflicts. Sometimes as the issue unfolds, there could be a conflict in some of the people on the team. So you may have people come on and off the team depending on which way the investigation goes. And you really need a lead investigator. So there needs to be someone and who is really leading it clearly, so you don't have different parties going in different directions and working at cross purposes. Again, in a larger organization, we would rely on people with the law enforcement experience because they're trained investigators. They know how to keep notes, how to drive it forward. But again, in a medium or small size company, it would be someone with those skill sets of like the law enforcement background to be the lead on it. You want someone who clearly is the lead.
In situations where I'm involved in assisting a client and we need outside expertise and we need to hire a consultant, my practice is to begin the conversation with even a potential consultant with a confidentiality agreement. And I don't put together a multi-page legalese written document. It's quite often just a simple exchange via email before I even tell them the facts of the situation. Here's one of the reasons why I do that. A lawyer obviously is there to sort of be conservative and protect your interests. But I've had situations where I've been on the phone with an environmental consultant and I've said, hey, do you have experience in areas A, B, and C? And they begin to unravel their experiences with specific references to specific clients, just kind of underscoring the idea that, everybody means well and has your best interests at heart in most instances. But it pays to be careful when you're engaging outside assistance and for them also to set forth clear lines of communication so you don't have them contacting an agency doing what they think is sort of a benign request for public information and triggering interest in your facility. Rick mentioned the self-disclosure. There are as many of you know, EPA and DEC have self-audit policies. You want to approach these situations very carefully in consultation with legal council, the audit policies generally set a number of conditions for penalty mitigation. EPA could offer as much as 100% reduction of the gravity component of the civil penalty, provided conditions are met. There are eligibility requirements that are, to a large degree, common sense. You can't be the subject of a notice of violation. This can't be something for which you've been a repeat violator, that sort of thing. Prompt reporting is often a condition of self-disclosure. You can't sit on a regulatory problem for 1.5 years and expect to be treated well under a self-audit scenario. EPA has, in many instances, a 21-day reporting period. DEC sets a 30-day clock, which can be adjusted under appropriate situations. EPA and DEC both encourage systematic discovery of violations. They encourage and want facilities to have a process in place for monitoring and detecting problems and managing them. So in some cases, the equation or the analysis as to whether a self-disclosure makes sense, in many cases will depend upon how compliant you feel you are. I mean, you're definitely going to have to weigh the benefit of a significant penalty reduction with the possibility that you're going to find a bunch of things you're going to have to fix, frankly. So, but it is and can be a very useful tool in certain situations.
All right, so a little look at some of the mechanics, and again, this is highly dependent on individual scenarios, but who do you interview, how far, how wide, what do you look at, how far, how wide, what kind of records, how far, how wide, I mean, it could be little, it could be medium, it could be large. Again, there's no rule. You really have to have, the team looks at it. You may start out small, end up talking to lots of people, circling back. You generally want 2 interviewers. You don't ever want to be in a situation where, I didn't say that. Yes, you did. No, you didn't. No, we've got a couple of people, one person generally, again, the lead investigator leading the discussion, someone taking notes, someone, monitoring follow-up and whatnot. And you want to get all viewpoints. Remember, this is an investigation. It has to pass the straight face test, internally and potentially externally. So you need to get all viewpoints, whether you like it or not. And you could, as you dig into an issue like this, you may find things that are just uncomfortable for you, uncomfortable for the organization. But you need to look. You need to look under all the rocks. Now, you don't have to look under every rock, but you need to look under a representative, set of rocks for each problem. All right. Photos, data, samples. Again, depending on the issue, you might be doing sampling. And again, this is where the communication back to the whistleblower, the potential whistleblower, is important. They may not realize what they've set in motion. Like I said, one of them, one of the bullets earlier, they could be right for the wrong reason. And as you start to unwrap this issue, it can be very complicated. And the whistleblower is thinking it's simple. He's ready to go to the news station. So you need to go back and let him know, well, we've got to do sampling, there's turnaround time, there's lots of different issues. Here's why it's taking longer, and kind of keep them in the loop on that. And then, of course, records. You may want to preserve records, electronic holds, today's age with all the different electronic communication media. Your IT people, you may want to copy and monitor accounts so you can see, who said what, when, where. That can be very helpful in an investigation. Obviously, it makes it more complicated, but again, it's a sliding scale depending on the gravity of the issue.
And so you may be listening to this thinking, oh, geez, this kind of sounds like an agency inspection, the kinds of strategies. So I get phone calls occasionally where a client has been notified that OSHA's coming and that there's an inspection. And so we go through the drill where we talk about assembling a team and babysitters to walk throughout the facility with the agency representatives, taking notes and doing sort of a parallel sort of a recording of what's being alleged and what the conditions are. Now, in the case of an in-house investigation, a lot of these principles apply, but with perhaps some subtle differences. For example, and not to be crass, but to illustrate the point, Whereas it might not be a good idea to take a photograph of, say, a dismembered person on the floor of your operations. If there are instances where an employee is alleging that there are unsafe conditions and it is incorrect, it's probably in your best interest to take a picture of what the conditions are during the period in question on the day in question to help keep the record straight. Just as it is useful to have accurate notes on who said what when.
Okay, you've done your work. You're coming to the end now. How do you close this out? All right. Well, you want a written report. So you want some findings, recommendations. Again, this doesn't have to be the Encyclopedia Britannica, okay? But you need to document what you found, what the recommendations were. If there's disciplinary actions, again, this is where HR comes, big time into the discussion. Are people being treated fairly and consistently, compared to other situations? All right. Again, depending on how it unfolds, people can get a little wound up. They want something, something maybe extreme. And again, this is where it has to really be fair and balanced, because once whatever comes out publicly, a lot of times a lot of this will ultimately be disclosed either publicly or at least internally within the organization. You want people to feel that whatever happened, if there was any discipline meted out, that it was fair. You don't want people to think that parties were treated unfairly. And you don't want to, as Steve mentioned earlier, if there's some sort of retaliation, you definitely don't want to have another phase of this when someone goes back and claims that they were retaliated or treated unfairly. So you want to look at that carefully. You want to have, I mentioned earlier that you want to have a requirement that parties cooperate. And this is one of the reasons that you need it there. We found many times, not many times, but sometimes, we could not necessarily prove, who did what where something was wrong. We fixed it, something was wrong, we're not sure who exactly did what. So we couldn't necessarily, there weren't necessarily any specific disciplinary actions against individuals, but we did have situations where people lied to the investigators, and that was cause for discipline. So you need to have that policy in place so that people know that they have to tell the truth. They don't want to feel like they're undermining their coworkers, undermining their department, undermining their site. But there has to be a policy and an expectation from the company that you tell the truth. If you get into one of these scenarios where there's a formal investigation, you need to tell the truth. And that needs to be part of the policy. All right. Corrective actions could be capital expenditures, could be legal or regulatory actions, getting a permit or whatnot. And some of that can take time, and this may be circling back to your whistleblower. Yep, this can't be solved right away. We've got to spend a substantial amount of money, but here's the timeline. Thank you for helping us find this out and fix it. All right. So you want to have your corrective actions laid out and look back at your management systems. Were there holes in the system, or the system maybe you thought you had in place that didn't work well, or things that weren't in place? Some of those items I mentioned earlier that you want to beef up and make sure that the different processes you have in place to handle complaints, collect complaints, and manage complaints. Look back and refine those if you find any deficiencies in that process.
On the issue of corrective actions, it's tempting sometimes to think about a corrective action as an admission. You receive a complaint, you conduct an investigation, you consult with legal, you make a determination on compliance, and you consider the economics, and you act accordingly. It's never a good idea to avoid fixing something that's broke if you think it will be perceived as an admission of wrongdoing. It's always better to correct a condition of noncompliance and to make your workplace safer, both from a regulatory perspective and obviously from an operational perspective. You lose money when people get hurt. You bleed money on the transactional costs of dealing with compliance matters. So I just wanted to reinforce that idea, because there have been instances where I think unfortunately plays too great a role in the decision-making process, sort of this prideful kind of legally driven But we know in instances of enforcement and under the case law that it's much better to correct a problem than to try to pretend it doesn't exist.
Okay, and lastly, you want to, after all of the dust is settled, you still need to monitor. Monitor and make sure there's follow through on the closure items. Make sure that they, the projects were completed, the money was spent. Look back to your planning steps, again, your systems and your planning steps to see where their improvements are, and then keep the issue on your network's radar, especially if you have more than one site. If you have multiple sites, sometimes something going wrong or an issue at one site, it can be similar at other sites. So you may take, kind of your learnings and look at what's going on across your network, even if it's only 2 or 3 sites, and make sure that you don't have the same problem at other facilities. And depending, you may do that as part of the investigation, depending on how serious it was. For example, if it's a serious, dangerous safety violation or concern, you may immediately look across your operations and say, let's make sure that situation doesn't exist in other places. So that could have been done earlier. If you haven't done it earlier, that's one of the last things you want to do to close things out. Steve?
So we've come to the end of the presentation. I don't see questions presented in the Q&A box. We love questions. We'd be happy to answer whatever questions you have. You can certainly contact Rick or me directly to discuss anything that might be of concern to you. And we appreciate you tuning in and listening to this today. We hope it was helpful.